Good afternoon, everyone. I want to go ahead and call to order our special called meeting of the Cobb County Board of Elections and Registration. We'll call the meeting to order at 3:04 p.m. We are here on the challenge of the qualifications of Ms. Alicia Adams to be a candidate for election to Cobb County Commission District 2 in the May 21st primary election. Just to kind of set a couple of ground rules and to give you a roadmap, we're going to go through a couple of announcements, and then we'll provide some information, I believe, for the benefit of everyone here, some references to the relevant law as we know it to be with regard to commissioner eligibility, that being the eligibility for someone to be a commissioner. And then the related law with respect to qualification is provided by, or provided in the Georgia Code. We'll then speak to the parties, and then I'll do a brief process overview of how the hearing will take place. And then at that point, we'll then turn it over to the challenger and the challenge candidate. So with that, I do want to make note of a couple of things. This proceeding is being taken down by a court reporter that is joining us virtually. So to that end, if you are speaking, please be certain to speak loudly and clearly. Further to that end, there is no opportunity for outbursts and talking by those of you that are here in the public area, because it will disrupt and make it complicated for our court reporter to take this down appropriately. As well as those that are speaking, if you'll be certain to state your name so that the court reporter will know who to attribute the statements to as she's taking the proceeding down. With that, we'll go ahead and get started. On March the 12th, Ms. Mindy Seeger submitted a written challenge of the qualifications of Ms. Alicia Adams to be a candidate for the Cobb County Commission District 2 seat. The bases for the grounds for that challenge is that Ms. Adams does not live within District 2. Moving on to the relevant law. So Cobb's enabling legislation, sections 2-22 as well as 2-23, set forth the requirements with respect to, for purposes of electing members of the Board of Commissioners, and I'm reading subsection B, from 2-22. Again, for purposes of electing members of the Board of Commissioners, other than the chairperson, Cobb County is divided into 4 commissioner districts. 1 member of the board shall be elected from each such district. Now, with respect to specific qualifications for a person to be eligible to be a candidate, at the time of qualifying, and this is coming from section 2-23, subsection B, at the time of qualifying for election, as a member of the board from a commissioner district, each candidate for such office shall specify the commissioner district for which that person is a candidate. A person elected or appointed as a member of the board from a commissioner district must continue to reside in that district during that person's term of office, or that office shall become vacant. With respect to the candidate qualification challenge process, that is set out in section 21-2-6 of the Georgia Code, and it provides that within 2 weeks after the deadline for qualifying, any elector who is eligible to vote for any such candidate may challenge the qualifications of the candidate by filing a written complaint with the superintendent, giving the reason why the elector believes the candidate is not qualified to seek and hold the public office for which the candidate is offered. So at the outset, we're going to take up those 2 requirements for someone to be eligible to submit a qualification challenge. The 2 requirements are: 1, the challenge must be timely, as the code specifies that it must be filed within 2 weeks following the deadline for qualifying. The deadline for qualifying in this particular election was a week ago today, March the 8th, and we received the challenge on the 12th. So the challenge was timely filed. The second requirement is that the challenger must be an elector who is eligible to vote for any such candidate. So as I noted, with respect to the first requirement, qualifying ended on Friday, March 8th, so Ms. Seeger's challenge is timely. With regard to Ms. Seeger's eligibility to vote in the Cobb Commission District 2 election, Ms. Seeger must be a registered voter in Cobb County and reside in District 2. Ms. Fall, have you confirmed that Ms. Seeger is a registered Cobb County voter?
Yes.
And with regard to her eligibility to vote in the Cobb Commission District 2 election, did you confirm that she is eligible?
Yes.
Okay. And I want to reiterate for those that may not be aware, on March the 1st, this board released a statement with regard to the maps that would be used for qualifying. And at that time, we noted that what has become to be known as the House rule maps would be used for candidate qualifying. And again, as noted, Ms. Seeger lives in Cobb Commission District 2, as noted in the home rule map, so she's eligible to submit the challenge. So we'll move on to the parties in this. Ms. Seeger, and you note that you are here.
Yes.
And Ms. Alicia Adams is here as well. Ms. Adams, I believe you are represented by counsel?
Yes, ma'am.
Okay. And Mr. Boring, counsel? So notice was provided to Ms. Seeger and to Ms. Adams of today's hearing earlier in the week on Wednesday. Please note that notice was also provided to the chairs of the Cobb County Republican and Democrat parties as interested parties, given they conducted the qualifying for District 2 seat. I was going to acknowledge the fact that we received a notice from Ms. Grubbs, chair of the Cobb County Republican Party, that she was unable to join us, but I do see her here at this time. I also want to just be transparent and speaking to the reason why this hearing needed to happen on such a quick turn. Again, qualifying ended on the 8th. Ms. Seeger submitted her challenge on the 12th, and obviously here it is 2 days later, 3 days later, we are here. As of Monday, we were advised that the secretary began building ballots. So the ballot building process began on this past Monday. Additionally, Georgia law, and we'll talk a bit more about that later, provides that the party that does not prevail in this hearing has the opportunity to appeal to a superior court the decision that this board makes, and that has to be filed within 10 days. And then, of course, we have this election that is quickly approaching. We've got UOCAVA ballots that will be distributed. Ms. Fall, I believe our office will distribute those ballots beginning April the 6th. So that demonstrates that time is of the essence, and again, that is the reason why we moved quickly to ensure that all interested parties could be present, hoping that they could be present, but that we would move forward with this matter. Moving on to the process. Ms. Seeger and Ms. Adams, and as well as Ms. Adams' counsel, they were provided with a copy of the procedures for this hearing, including notice that the burden is on the challenger, Ms. Seeger, to demonstrate by preponderance of the evidence that Ms. Adams does not meet the residency requirement to be a candidate. Ms. Seeger, you will be provided with 30 minutes to present evidence in support of your challenge. During that time, you will obviously address the board. You will also have the opportunity to ask questions of Ms. Adams, the challenged candidate. Mr. Boring, I presume you will be presenting evidence on behalf of Ms. Adams?
That's correct.
Okay. And you will also have the opportunity to ask questions of Ms. Seeger, and you will also be allotted 30 minutes. Thereafter, I know that there will be a brief presentation from Director Fall as it relates to the process that her office or our office undertakes. And then if needed, this board will go into executive session, and the decision that we make will be made in open forum. With that, Mr. Boring, I know you and I spoke very briefly at the outset. Do you anticipate eliciting any testimony from Ms. Adams?
No, we don't.
Okay. All right. With that, Ms. Seeger, if you will stand up, I just need to swear you in. Raise your right hand. Do you solemnly swear or affirm the testimony that you provide today during this proceeding will be the truth and the whole truth? I do. Excellent. Thank you. Oh, yeah, we're going to have her come up. So you can go ahead and come up.
I wasn't sure if you were ready for me.
No, absolutely.
Good afternoon. I will try to not take the whole 30 minutes because I think this is pretty cut and dry.
No worries. And do realize also during the course of this, and I neglected to mention that the board has obviously the opportunity to ask questions of you as well as you. But go ahead, Ms. Seeger.
Happy to do my best with that.
Thank you.
Chairwoman Silas, board members, Director Fall, Mr. White, thank you for the opportunity to present this challenge today. My name is Mindy Seeger. I am here today as a Cobb County resident, Commission District 2 voter, and an elector in good standing. I hereby challenge that Alicia Adams does not meet the residency requirement for the District 2 Commission office as required in OCGA 21-153. Let me begin by sharing that I hold the belief that stepping up to run to serve one's community is to elected office to serve one's community is one of the greatest tasks in public service. I don't know Miss Adams. We actually just met in the hallway. I do not know if this error was the result of intention or misguidance. I respect her right to run for any office in which she is qualified at the appropriate time. It brings me no joy to bear the burden of questioning Miss Adams' qualifications. I feel a sense of duty that all candidates that wish to represent me and my family all follow the same rules. As stated in my complaint, having a particular interest in this seat up for election this year, and having followed the home rule litigation very closely, I am uniquely aware of the timeline of events that have led us to today, including this board's March 1st statement related to the various litigations involving all 5 of Cobb's electoral maps, the status of each litigation, and the resulting map to be used for the purpose of qualifying candidates. That statement confirmed that the map known as the home rule map was to be used for the purpose of qualifying candidates in districts 2 and 4 up for election this year. By the end of qualifying on Friday, March 8th, a total of 7 candidates had qualified for this office. I believe in my complaint I said 8, I miscounted. I undertook the task of verifying that each candidate lived in the boundaries of that map, and 6 of the 7 candidates' residencies are in the district. Ms. Adams' resident is not, and therefore I challenge her eligibility for this office. As of Sunday, her address was not provided on the partisan candidate list, and her declaration of intent was not available, so I submitted an open records request for it. The declaration of intent, signed by Ms. Adams, indicates an address of 2000 Esquire Drive Northwest in Kennesaw. Using the Cobb County Find My Commissioner tool and cross-checking that against the address to the district map, of which I'm very familiar, I confirmed Ms. Adams resides in Commission District 3, which is not up for election this year. On March 12th, I filed the challenge as I felt compelled to ensure all candidates for this office are following the rules set forth by this board. It is my understanding that the respective partisan party chairs were advised by Director Fall how to verify candidates met the residency requirements for their respective offices. This guidance seems to have been followed for all other candidates in this race, including the other District 2 candidate qualified by the Cobb Republican Party on Thursday. The MGJ reported that the Cobb County Democratic Committee had to turn away 2 prospective candidates as they did not meet the residency requirement as outlined. The rules were adhered to by both parties except in Ms. Adams' case. There is no factual dispute here. Ms. Adams' address has been provided with her qualifying materials, so she's either in the district or she isn't. This board should be able to make a determination accordingly, and I thank you for your consideration and continued service to our county. Are there any
Thank
questions
you.
at this time?
Yes, thank you, Ms. Seeger. Does anyone have questions from the board at this time of Ms. Seeger? Do you recognize we also need to ensure we provide an opportunity with respect to time for Mr. Boring to pose any questions to Ms. Seeger, if that's his choice?
Yes, I do recognize that. I do have one question on something you said. I just need clarification.
Sure.
You said 6 of the 7 candidates qualified. Are you sure that is correct?
Let me go to.
I believe it's actually 4 of the 7. 5 with, no, 4.
Okay, so I have the list that was submitted by the Republican Party on March 8th. Lists 2 candidates, Ms. Alicia Adams and Ms. Pamela Reardon.
Correct.
So that puts us at 2. On the Democrat list, and ours is a bit longer, let me look.
I believe your statement was 6 of the 7 qualified for a home rule District 2.
Correct. So the other candidates would be Eric Allen, who is in District 2, Will Costa, who's in District 2, Jaha Howard in District 2, Kevin Redmond in District 2, Tanisha Wharton. So I count 1, 2, 3, 4, 5 Democrats and 2 Republicans, so 7.
So can we correct the record that it's not 6 of 7, it's 5 of 7, then in 2?
Respectfully, no, ma'am. 6 of the 7 candidates' residencies are in the district. What I'm outlining there is that Ms. Adams is the outlier. Of the 7 candidates that officially qualified, she is the only one whose residency is not within the district.
Okay.
Does that helpful?
Yep.
Thank you.
Thank you for the clarification.
No problem.
I will reserve questions. Mr. Boring, do you have any questions for Ms. Seeger?
A few, Judge.
Okay.
Famous last word, Judge. And it's habit also for attorneys to say just a few questions and we don't really get it. So, oh, good. It's going to be karaoke here. All right.
Well, now we're talking on a Friday afternoon.
Exactly, it is. It is a Friday afternoon.
Okay. May I proceed?
Yes, please do.
And Ms. Seeger, how are you employed?
I'm all right.
Huh?
I'm good.
How are you employed?
How am I employed?
Yes.
I do some bookkeeping, contract work. I've also done some political consulting.
Okay.
But kind of self-employed, doing a few things in a few places.
Right. You're not an attorney,
I am
correct?
not.
Okay. You're not, I guess, specifically an elections attorney, correct?
I am not an elections attorney.
Obviously, you're not a judge, correct?
I am not.
Okay. You're not with the Secretary of State's office, correct? Not with the Attorney General's office. You play no role in deciding what maps are correct, what are not, what are legal, what are illegal, correct?
I am at the mercy of the same public information as the rest of Cobb County.
Okay. And so you said you followed this case or this particular situation throughout the political process, throughout the legislative process, and I guess through the courts, correct?
Through the courts, I've attended the hearings. I've also attended several legislative hearings where there were some attempts to change some bills along with this. I have been following this very closely.
Okay. And so you're aware that the Secretary of State for Georgia, they supervise elections for the state of Georgia, correct?
I understand that's part of their role, yes.
Okay. And you understand that they have found that the current map that the Board of Commissioners has instituted that has this particular District 2 is unconstitutional and inappropriate. You've seen the Secretary of State say that, correct? That it's reckless for the Board of Commissioners to actually utilize the map that they're using?
I'm familiar with the statement of the Secretary of State, but I'm not aware of them having any judicial powers.
Okay, but you're aware that the Secretary of State says this is improper, right?
I'm aware of his statement, yes.
Okay, the Attorney General the same, correct?
I've read his amicus brief, yes.
Okay, and you're aware that a Superior Court judge of Cobb County has actually held that this particular map, we'll refer to it as the home rule map, is unconstitutional, correct?
I'm aware that that is under appeal, yes.
But you're aware that a judge held that this very map is unconstitutional.
I'm aware of her ruling and that it is under appeal by this county.
Okay, and so you're also aware of House Bill 1154, which created, we'll call it the General Assembly map, correct?
Correct.
Okay, and you've looked at the residency requirements and the candidates and that type of thing, right?
Ad nauseum, yes.
Okay. Back in 2022, Ms. Adams would be qualified for District 2, correct?
Prior to the home rule institution by the Board of Commissioners, that would be accurate.
Okay. And we've got these two maps now that the courts are arguing about. So the one that was actually in place, status quo, before all of this fighting about the new maps was the 2022 map, correct?
Can you repeat that?
Yeah. 2022 was the last county election where you actually had a map where people weren't fighting over it, right?
There have been a lot of maps that have been fought over in Cobb County. I don't know if I want to attest to that under oath.
Okay. In 2022, those elections, you actually voted in District 3, correct?
I did.
Okay. And so under the new, I guess, House Bill 1154 map that the General Assembly passed and that the Superior Court of Cobb County held was the constitutional appropriate map, you would not be in District 2 under that map, correct?
If that were the law of the land, but under appellate law in Georgia, it's my understanding that the last legal map passed is the one that we're going with per the guidance of this board's attorney in the statement that was put out by them.
Okay.
It's also
And,
the same map, if I can. That's also the same map that is holding the current Commission District 2 commissioner in her seat until that is fully adjudicated through the state Supreme Court.
Okay. And again, you're not an attorney, right?
I've just slept at a Marriott or two.
Right. You're not a judge.
No, I'm not.
Mr. White's not a judge, is he?
I'm not aware of him having a judgeship.
Okay, and you're aware that the elections attorneys, the election board, they did not take a position on whether the appeal, the supersedious, should be or would be in place to actually stall the General Assembly maps from being put in place. Are you aware of that?
I'm aware that they and the Supreme Court have made no motions on that to this point.
Right. The only order that's in place is the Superior Court of Cobb County that held that this particular map that you're challenging or that you're saying she is should have to qualify under is unconstitutional.
I have read the judge's ruling. My understanding that is under the appeal that has been filed, the supersedious, or what most people would refer to as the stay, is what is in place. That is what is keeping Commissioner Richardson in her seat at the current moment, and that is what this board had decided that they had to go on in lieu of other rulings from the higher court. The Supreme Court did not make a ruling and has not. They issued oral arguments. Can I grab something from the table?
It's in April.
So let's walk through a timeline of events in the last week plus. On February 29th, the state Supreme Court released a statement or posted that they would agree to the expedition of the case which was requested, and that they would hear oral arguments. On 3/1, the next day, this board produced a statement explaining on all 5 electoral maps which maps they were, the status of those litigations, and which maps they were using in all 5 cases.
Correct.
Okay? On March the 2nd, Senator Setzler sent a demand for cure. On March the 5th, Larry Savage filed an injunction. On 3/8, Ms. Adams qualified for office, presented her qualification for office. On 3/11, I submitted an ORR. On 3/12, I filed the complaint. 3/13, the hearing was set, and 3/15, we're here.
Right. And so getting back to the point of my question, you would agree that the Secretary of State, the Attorney General, a Superior Court judge for Cobb County, and Legislative Counsel for the General Assembly have all said that the map that the Board of Elections are proceeding under is improper. You'd agree with that?
I would agree that that map was followed, and all of the other candidates who qualified for office qualify under that map.
Okay. So your answer is yes, you're aware that all of those other entities that are involved in elections have held that House Bill 1154's map should be the one that should be considered and should be used, not the home rule map.
this board certified through a statement that they would be using the map that's commonly known as home rule that was part of House Bill 1256.
I get it. So the board is doing something contrary to what a Superior Court judge has ordered. You agree with that?
I see their statement for what it is.
Okay.
Those were the rules that were set forth by this board to be followed by all candidates.
Right. And so they are actually usurping the role of the courts and making their own decisions in spite of what the court held.
That's not for me to make that ruling.
Okay. All right. That's all I have. Thank you.
Thank you, Mr. Boring. Does anyone have any further questions here?
Madam Chair, I just, for purposes of the record, I don't think Mr. Boring has anybody has used his first name, and since it's
I
to be transcribed, I want to allow him to say whether he wants to use Chuck, is that, or Charles?
Yes, I'll go not with my government name, but my nickname, Chuck.
Chuck, okay.
Charles Boring, but I go by Chuck. If you call me Charles, I will not answer. I don't know who you're talking about.
I will be certain to call you Chuck then.
Thank you.
Anything else at this time?
I actually do have a couple of questions for
Sure.
you, Ms. Seeger. I know that you've indicated that you followed the litigation at the county level right on up to the Supreme Court. You made reference to the Supreme Court ruling that was issued on the 29th.
Yes.
Are you familiar with any other litigation in the case or at the Superior Court level?
I was made aware that there was an injunction filed by Mr. Savage on March 5th, but I don't know the status of that. The Cobb Superior Court clerk records are not up to date for that for public view.
Okay. Any other motions that you might
Not
be
that I'm aware of, no.
Okay. All right. Excellent. Do you all have any questions?
I do have another question. You
Yes, Ms.
had
Fisher.
said that the stay, the home rule map, is what is keeping Commissioner Richardson in office. Just for clarification, I believe that the appeal is what is keeping Commissioner Richardson in office at this time. Just to clarify, that's my understanding, that there has been no ruling by the court, and this board has been put in an untenable situation by that. So I just wanted to clarify, it is not the map itself, it's the appeal to the Supreme Court. So for clarification of the record.
Thank you, Ms. Fisher. I believe it's the appeal that has given rise to the supersedious, also known as stay. for
Yeah, I think we're
clarification.
saying the same, we're on the same page with that, just we're saying it a little bit different. My understanding as a non-attorney is that the appeal is in lieu of any other rulings from the court to the contrary. The appeal is what provides the stay or the supersedious, as known. My Latin is not that great, but that's what provides that, and that is what, and the fact that Commissioner Richardson has been able to stay in her seat past when that 1154 map was due to go into effect is because that is the home, what's known as the home rule map is what has been in place since October of 2022.
I haven't read the entire ruling, all the paperwork filed. Did the Supreme Court, in their decision, rule which map is actually stayed?
They
I
have-
don't believe they did in what I read.
So this, give me just 1 second, I have it here. So they've not made a ruling. What the Supreme Court released via order on February 29th, the Honorable Supreme Court met pursuant to adjournment, and the following order was passed in Cobb County v. David Flom et al. Appellant's request for oral argument is hereby granted. Oral argument will be advanced from the May 2024 to the April 17, 2024 calendar to be held at the 10 a.m. session. Although any issue properly before the court may be the subject of argument, counsel should be particularly prepared to address what, if any, decision by the appealees about their future conduct would be aided by the elimination of uncertainty regarding the legality of the challenged map. It's just an announcement that they're going to be hearing oral arguments. They've not made a ruling, and they're set to hear oral arguments April 17th. If we're following the elections calendar, that's 30 days after qualifying and 30 days, actually early voting starts the next day and 30 days prior to the primary election, which is why I believe this board took action to make a decision which way they were going to go based on what was available to them.
So they have not said which map is actually the ruling one.
It's still pending.
It is held in abeyance, I believe, was the term, this day?
That's a question for the attorneys. I don't want to answer that
Okay, thank you.
definitively. Sure.
Any further questions for Ms. Seeger? Okay. Thank you, Ms. Seeger.
Thank you.
I'm reticent to refer to you as Chuck. You're Mr. Boring. We just go ahead. I will.
Do you want argument at this time, or just us putting up our case as far as any introduction of evidence and things of that nature?
I would say you can present your case, and we will take some time to inquire of you with respect to what you present, and then you can present arguments.
Okay.
But do you really realize it's 30 minutes, and I am keeping track? So
Well-
what would be preferable for you? May I give you an indicator when you've got 20 minutes left and 10 minutes left?
I'm not going to take 30 minutes of your time, so.
Okay.
Famous last words, right?
Indeed, indeed. Go
Okay.
ahead.
Well, the evidence that I'm going to just provide the board, these are things that are in the public realm that you're going to have anyway, so it's just more for the record. So when it does go up, if it does go up to the Superior Court of Cobb County on appeal, whichever way this goes, there is something in the record. So the court will know what we were talking about when I was asking questions and when Ms. Seeger was making her statements. So I have exhibits 1 through 6 to provide to you all. I guess there's no formal way. I'll just bring it up to you.
Yes.
Well, let me go ahead and put on the record exactly what it is first before I bring it up to you, so that's clear on the record. Exhibit 1 is actually the order on cross motions for summary judgment where Judge Harris held that the Board of Commissioners decision in that particular map was unconstitutional. The fact that they did that was unconstitutional. Exhibit 2 is an opinion from October 3rd of 2022, long time ago, from Legislative Counsel to the General Assembly, also opining that that would not be appropriate, and that House Bill 1154, that map was appropriate. Exhibit 3 is I think Ms. Seeger referenced it, March 2nd, 2024 letter from Senator Setzler to the Board of Elections and Registration. You all obviously have a copy of that, but I have a copy for the record as well. Exhibit 4 is an AJC article with the statement I referenced, or excuse me, a statement from the website of the Secretary of State that I was referencing, March 4th, 2024, where Secretary Raffensperger referred to the Cobb County Commission's decision to proceed with the commission draw maps being reckless and inappropriate. Exhibit 5 is an AJC article back from 2023, I believe, where the Attorney General also had commented about this not being legally binding, the Board of Commission map. And then Exhibit 6 is just a copy of the two maps in question, 1154 and then the Board of Commission's map, and I'll provide those to you now.
Thank you.
And before argument, I'm happy to take any questions.
I do have a question. Mr. Boring, are you familiar with any other motions that have been filed beyond those that have been described in the Floam v. Cobb County matter?
I got my engagement letter signed this morning. I am familiar with some of the filings. I know I did read particularly, which I think was interesting. It just shows the entire confusion of this whole process from Mr. White talking about the supersedious issue, recognizing that it's likely that doesn't even apply to a declaratory judgment. That is a very definite issue in this case. So I think that was in the issue when you all were, and rightfully so, asking the Supreme Court, come on, hurry up, we need a decision sooner rather than later. So I appreciate you all trying to get a decision sooner, but as we know, sometimes the judicial process does not work as quickly as everybody would like, and for a myriad of reasons, a lot of them very appropriate because there's a lot of business to do at the Supreme Court. But I get the importance of needing decisions and needing finality on this. So as far as other motions that are filed in the case, I had read some of the briefing in the underlying Floam case. Am I pronouncing that right? Flum?
Yes, my understanding is you are.
So I've read some of the filings in that. I'm not familiar with any other filings in the Flum case. I think there was a motion to intervene. I didn't read it, but I've seen a motion of that nature.
Okay. That is indeed the motion that I wanted to inquire
Okay.
with you about, actually more specifically, the order
Okay.
as was issued by Judge Harris. Are you so you're familiar with the motion? Have you?
I've seen there was an order. I haven't read it. It was just
Okay.
part of the materials I've provided, or have been provided, printed out, but I've not had an opportunity to look at that for today.
Okay. I'm gonna ask you to come on up. I want
Okay.
you to have an opportunity to take a look at that order, sir. Here. It's brief.
It is only 2 pages. And I know Judge Harris well. I know she'll take this the right way. I am shocked at the brevity of this one.
Indeed.
Okay, yes.
Okay. If I might ask, one lawyer to another.
Yes.
What is your interpretation, if you will, of that order? Essentially, the last portion of it, where she indicates that she lacks jurisdiction over the case?
Okay. Oh, on the issue of the supersedious decision, it says that she lacks jurisdiction over that right now. Yes, because they're dealing with that.
Okay.
So that's how I read that. And I think with the supersedious too, from what I remember from the Supreme Court's decision, they delayed making a decision whether to lift one or even decide whether it applies, period. So the Supreme Court didn't opine whether a supersedious even applies to this, is my understanding and my reading of it.
Okay, good deal. I'll take my order back.
Okay.
Thank you. I won't make a statement because it would be a statement, it wouldn't be a question. You can go ahead and proceed with your argument.
Okay. I know you all have kind of been put in an untenable position in this case because you've got this warring over maps that's been going on for some time now. That's why we have courts to make decisions and decide. In this case, actually, my client, Ms. Adams, is qualified under what has been ruled by a superior court, what the Secretary of State has opined, what the Attorney General has opined, to be the lawful constitutional map that applies to the county commission race. And so I know that there are arguments being made by also to say that the Board of Commission map should be the one used, that that's actually what the Board of Elections have used. And so there's a lot of controversy about that, obviously. If you go back, though, if we're really trying to go with the status quo, you revert to 2022 and look at what the map would have been then. Using that map, Ms. Adams would have been qualified. Using the constitutional map as determined by the courts, Ms. Adams would be qualified. And so at this point, I'm going to ask you to deny this motion, this petition, because what we have is determinations by every level except this Board of Commissioners, that House Bill 1154 is the proper map and is the legal map in this case. The Board of Commissioners has inappropriately, I believe, from a legal sense, substituted their opinion and their legal analysis for the Secretary of State, for a Superior Court judge of Cobb County, for the General Assembly of the state of Georgia. And because of that, I don't think it's appropriate, or legal, that this challenge from Ms. Seeger is appropriate, because she does not, under what I believe and what our argument is, the legal map, she's not qualified to even make this challenge. I believe Ms. Adams is properly qualified under the legal maps. So I think at this point, the biggest point is the Board of Commissioners does not have the authority to overrule a Superior Court judge in a legal proceeding. That is a separation of powers issue. That is usurping the entire process. Politicians, elected officials, you legislate, you execute, You do your jobs. The courts are supposed to do their jobs. And now in this situation, I believe the Board of Commissioners has taken on that job of the courts and ruled that we're going to go with this specific map that we've decided should be appropriate and use that in spite of everyone else involved in the elective process from a state level, from the courts level, that would be inappropriate. So we're going to ask you to deny this motion to disqualify Ms. Adams and that she continue as a properly qualified candidate for District 2 in this case.
Okay, thank you.
All right, thank you.
Ms. Fall, Director Fall, I think now would be appropriate for you to share what you have to offer with respect to the qualifying process, specifically what you and members of our staff are responsible for.
Sure. So we were running multiple qualifications this week. During qualification week, we run the nonpartisan qualification at our office. So all of our judges came to us. The nonpartisan judges. We were also running the City of Kennesaw special election qualification at the same time. And then the partisan candidates qualified at their respective county level offices. So the process that we had in place was that the parties would scan us over the declaration of candidacies and affidavits from whoever they were working with at that time. And then they would send that to myself, to Kara Pringle, our elections manager, and then Melissa Miller and Kevin Reeves, our registration supervisors. And they would confirm first that that person lives in that district. So for any districted position, whether it was school board or county commission, that they lived in that district under, for county commission, the home rule map, since that was the map in place. And then they also were checking for the residency requirement, that they lived there for a full year. So we had, one where we needed to get a lease, and so they're the ones that are checking kind of those requirements, and then they send back approved for, this district, or this candidate does live in this district. So this particular submission was a little bit different because it didn't just have the affidavit. It also had a letter from who I believe is the first vice chair, attached to the packet, explaining that they're unsure of which map to qualify under and that they wanted to submit Ms. Adams' qualification on like a let's see
Dual
what happens.
basis, maybe?
Yes, yeah, on a dual basis. And so instead of Kevin and Melissa replying, I went ahead and said, I'll handle this one since this one's a little out of the ordinary. Spoke with counsel and then replied with what was in the purview of the party's decision and ability to qualify that candidate under the map that we had chosen.
Okay. What did you and your team do further from that perspective? Because in this letter, and I have a copy of the letter, and each of the board members have a copy of it as well, and if I might just read it for purposes of getting it into the record. To the Cobb County Board of Elections, Kara Pringle, Tate Fall, Melissa Miller, Kevin Reeves. I am submitting this paperwork for this candidate as a conditional submission for approval, as I am confused and unclear as to whether this candidate will qualify because of the current commission map confusion. The candidate shows on MVP page as Commission District 2 and the GIS map as Commission District 3. Is there anything that you can share with us with respect to the purported confusion that's referenced in the letter?
Yes, so with the MVP, I had mentioned in our February public meeting, I also believe January, but I know definitely February, that MVP would not be updated prior to the March PPP because we didn't have a commission map yet. At that time, it was our understanding that we needed all of the maps in place in order to complete the redistricting process. Therefore, we couldn't update anyone's maps with all of the other approved maps. So because of that, we worked with the Cobb County GIS department to create a lookup tool where they layered all of the state-drawn maps, the state house districts and commission, or state house district, state senate, and the state representatives, and then the school board maps, those that had all been approved, and then the home rule map. So they layered all those together. So all the parties had to do was type in the candidate's address and it would pull up all of those districts, all that information. So I sent that out to the party chairs the week before qualification, again, reminding them that they needed to use this lookup tool, not my voter page, because my voter page would be incorrect, and that is the tool in which they use to check someone's qualification in terms of residency. And then on the same end, we're checking that on our end as well.
Okay. And you indicated that you shared that tool with the chairs of both county parties?
Correct.
Okay.
Yes.
And were any concerns raised with you with regard to the use of the tools, how to go about confirming whether a candidate resided in the home rule district?
The only question I received initially, I believe, was Ms. Grubbs. It was confusing because when you look at the tool, there's a search box, and that's not the search box you use to search the layers. It just pulls up the address. So it would drop you a pin, but it's not going to give you the information you need. So you needed to click a little map icon to pull up that search box that then search those layers. And so I included that in the directions with the screenshots. And so I think Ms. Grubbs she thought that maybe it wasn't working. I think she had maybe used that initial search box. And then once I made sure, because I did the same thing, because it's a search box, that you click the icon to bring up the layer search box, that's when I believe that she was able to utilize that tool.
Okay. And
And
so
there were no
did
further
you have any
questions.
further concern about the inability of her, or even for that matter, the Democratic Party chair's ability to use the tool?
No.
Okay. Does anyone else have any questions for Ms. Wall?
Thank you.
Okay. At this point, if there are no further questions, in normal hearings, you'd have an opportunity for a closing argument. Are there any you each had some additional time left over. I don't know as to whether there are any additional statements that you would like to make, Ms. Seeger, having heard what Mr. Boring made reference to, as well as the conversation.
Madam Chair, let me just check, since she's the challenger, she can either go, you can go first, or you can wait and go last if you want to, it's up to you, if you want to procedurally.
I'm okay to go first. I just have one or two things that I just want to clarify or kind of ask, and one of them is kind of in the form of a question, so it would be okay, whichever. First, is that all right?
Yep, you are permitted to ask him questions. Thank you for the clarification, Mr. White.
Okay. So there were a lot of questions, a lot of information there. The one question that I have, or kind of a statement and then a question. My understanding, and this is probably a little bit simplified, but this board set forth rules of which maps were to be followed that were adhered to by all parties. What I find interesting is that the Republican Party who qualified this candidate also qualified another candidate who would only live in District 2 if we were under the home rule map. If we were under the 1154 map, Ms. Reardon would not qualify. So I don't think there was a confusion there that the process was obviously, I think, understood in that was done, and that question, I was unaware of the first vice chair's letter submitting this candidate submission differently. I would be curious if the same confusion or question was raised by that same party for Ms. Reardon's qualification, being that she's kind of uniquely qualified in the opposite. And then the last question that I have, this is the District 2 commission map that we're operating under. Where on this map does Ms. Adams live?
Okay, so statement and then the question. Okay. She absolutely does not live in that map whatsoever. Of course, our contention is that that's an illegal map. Why would Ms. Reardon have also qualified in the spirit of St. Patrick's Day? I think that they were probably both worried about shenanigans that are going on right now with the argument about the maps. And so in order to make sure they had a candidate qualified, I haven't discussed with them the motivations or anything, but it would make sense to me that they need to cover all their bases depending upon what the courts are going to rule. I mean, it's obvious. As a litigant and as an advocate for my client, it's obvious to me what the courts have held and what everybody has held should be the appropriate map. That failing, you never know what the courts are going to do in the end. And so I assume they wanted to have somebody qualified under both maps, just in case. So that's my answer to that.
I wasn't aware that we had two alternate sets of rules, but that's for this board to decide.
Mr. Boring, do you have anything further?
See, y'all got worried when I stood up. Now, I think I made the arguments, I made my positions clear, so I'm not going to take up any more of your time. I do appreciate you hearing our response to this, and we ask that you please reject the efforts to disqualify Ms. Adams right now.
Okay, thank you. Ms. Fall, I actually do have a question, as noted by Ms. Seeger. She made reference to the submission of Ms. Reardon's information. So did you receive, I will ask on your behalf, did you receive a similar notification or communication from anyone in the Cobb Republican Party expressing confusion in connection with the submission of Ms. Reardon's information?
No, I believe when we received the qualification packet for Ms. Reardon, let me get it pulled up, that there was not an additional letter attached. Let me just scroll through. So I did receive it from both Childress, and it was just the scan with, let me make sure. When I open it up, it has the contact sheet first, and then her declaration of candidacy and affidavit second, and that's all. No additional question in either the body or the attached scan.
Okay, so the confusion, or the statement of confusion was only submitted in connection with the submission of Ms. Adams' affidavit or statement of candidacy?
Correct, and that was on 3-6, and then Ms. Reardon qualified on 3-7.
Okay, thank you. If no one has anything further, Daniel, given the fact that we are here is an outgrowth of the varying litigation matters that are pending, I believe it's appropriate to go into executive session in connection. Go ahead.
Yes, so one of the reasons for executive session is potential litigation, and since we've already had at least one attorney here reference that the possibility of an appeal, I think that's appropriate to go in executive discussion, just to discuss the legal issues associated with that.
Okay. Is there a motion to move into executive session?
May I ask a question first?
Oh, certainly. We'd
That's
inquired as
okay.
to whether there were any additional questions. Go ahead.
Will you then talk to Daniel? So I thought I'd wait.
no
Okay.
I'm sorry, who's the
Do you
question
think
directed to?
you and Daniel? Okay. Is it appropriate to discuss why and how our decision came about to use the home rule map versus the one we followed for a year and a half? Do you think that would be appropriate prior to executive?
Yeah, I mean, at present, the matter, and we'll refer to our counsel to provide some guidance here, but, at present, the matter before us is residency. But Daniel, do you believe it appropriate to discuss? I mean, the statement has been out for over a week, so the statement's out there with regard, and it sets forth the bases for why.
Everyone may have not had the opportunity to read that
That's a
press
fair
release, and I think this is a very important issue of how we came about choosing a map that we did not stand behind until the last hour, and we're getting ready to make a really, really critical decision.
Right. Well, I mean, I struggle in taking off my lawyer hat because it's innate in me. But I mean, obviously, certain of our communications are subject to attorney-client privilege, but I will defer to Mr. White with regard to what he believes is appropriate to speak to in this public setting.
Yeah, I don't mind giving just a brief update of just going to kind of track what was in our statement anyway. So if that helps to build the record, that's fine.
Sure.
So yeah, just a sort of a real thumbnail sketch of the history of how we got here. There was a, everybody sort of has followed the timeline of when the maps were passed, and I'm not going to get into that issue, but there was a lawsuit filed last year that actually named Board of Elections and Cobb County. That one was dismissed. It was then refiled with a couple of different plaintiffs that aren't in the case anymore, but only against the county. That was simply an action for declaratory judgment. There was no request in the lawsuit for an injunction. That's going to come back in later, but that's an important note. And so that was litigated over the course of most of last year. We were not a party to that litigation, but I did attend on behalf of the board and listen to the arguments. And so, as we know, Judge Harris ended up issuing an order on the cross motions for summary judgment, and in that order, she considered all the parties' arguments. She found that the Flomes, who were the remaining plaintiffs, well, two of the three remaining plaintiffs, did have standing, and that they could bring their claim, and then she entered the order finding, considering all the arguments about the constitutionality of the home rule map resolution. She considered 6 or 7 arguments against it and found only on 2 of them did she uphold it, but those 2 were enough to find that the home rule map resolution was invalid. On the day of that order, the county attorney's office filed a notice of appeal, and so that appealed that matter immediately, and under OCGA 5646, there's an automatic supersedious that applies in civil cases. It's important to note that if an injunction had been granted along with the declaratory judgment, that would have shifted the burden to the county to have the injunction lifted, but because there was no injunction filed along with the declaration proceeding, the question remained as to what is the effect of what's the effect of the stay that by statute goes into effect, and is it binding on this board? Is it binding on the public in general? Does it apply to an unconstitutional law? So those are all questions we considered. We invited. The appeal proceeded. The court and I'll just go back and mention that order issued on January 8th, and there were motions filed within a week or two asking to expedite the appeal by the Flomes. The court granted that motion, and both the Flomes and the Attorney General's office invited the Supreme Court, I should say, to expedite the appeal and or to lift the supersedious or find that it doesn't apply. And the Supreme Court did not rule on the supersedious at that time. They issued an order on January 29th, saying that the issue of supersedious was held in abeyance, but they expedited the appeal and had briefing to be completed on February 21st. That was only less than 2 weeks before qualifying started, so this board felt it appropriate to file an amicus brief to bring those deadlines to the court's attention, among other deadlines. I know at that point, the appellees, the Flomes, the Attorney General's office, and this board had brought all of those deadlines to the Supreme Court's attention, and it was my hope that because they had expedited the appeal to be fully briefed by the 21st of February, that they would either issue an order, making a final ruling so that we'd have this information before qualifying, or that they'd at least rule on the supersedious issue. Unfortunately, on the 29th of February, just 4 days before qualifying, the court entered an order that did not address the supersedious issue at all. All it did was said we're going to advance oral argument from May to April, and then it asked a question that may seem a little confusing to the general public, but for lawyers that read it, generally that question focuses on whether the party bringing the action has a right to declaratory relief. So the court said to the appellees, be ready to address the issue of standing before this court. And so at that point, because they had not ruled on the issue of supersedious and had been invited to by 3 different parties, and in fact pointed to a case, City of Atlanta versus Mays in 2016, where the court did lift the supersedious and allowed an annexation referendum to proceed, they had seen that and been asked to rule on it, and they didn't, and instead they just moved it forward to be heard in April. At that point, based on my guidance, I told this board that I felt like that was the best information we had at this time was that the supersedious, because there was no injunction in place, there was no injunction filed by the plaintiffs, it was just a declaratory judgment, that the supersedious would hold that the prior resolution, the home rule resolution in place, and that we needed to move forward because qualifying was going to begin and we needed to start the ballot building process. And that was the best information we had. I know this board had the legal rule, the summary judgment ruling from Judge Harris to consider, and then the statute 5646, along with the request for the Supreme Court to consider. And it was my advice to this board that based on the current status of the litigation and the applicable laws that the board needed to move forward with qualifying using the home rule maps.
If I might ask, Mr. White, the order that I referenced earlier in speaking with Mr. Boring on the Republican Party of Cobb County's motion to intervene,
Yes,
is there anything in that order that you believe to be relevant?
Yes, thank you, Madam Chair, for remembering to bring that up. That is something, and I was going to ask that the board included in the record. But last week, the Cobb County GOP moved to intervene in the Floam case and asked Judge Harris to make a ruling about which maps would apply. And Judge Harris actually entered a ruling on March 12th. And the relevant portion for purposes of this discussion is at the end, where she states that because she denied the motion to intervene, and she says, because the Supreme Court has expressly reserved ruling on the request to lift the supersedious, this court concludes it lacks jurisdiction to determine the party's motion to intervene. And again, that to the layperson may sound a little confusing, but what it implies is that Judge Harris, she is sort of stating that the supersedious is in place, and she doesn't have any jurisdiction to enforce her prior ruling finding the map unconstitutional. So that's, again, that was issued after this board issued the statement and took my advice regarding the map, but that it does seem to support the current position that the supersedious is in place, and the court's not, feels like she can't enforce her, the Superior Court feels like it can't enforce the current order.
Okay, thank you. And thank you, Ms. Fisher. It was very helpful, I understand. I oftentimes take things for granted, and that's my apology, being an attorney. That being the case, unless there is anything further, I believe there was a motion, or I was requesting a motion to enter into executive session.
So moved.
Thank you, Mr. Bruning. Is there a second? Second. It's been moved and properly seconded to move into executive session for the purposes of discussing potential litigation. All those in favor? The motion passes unanimously. For those of you that have not previously been with us, when we move into executive session, we do request that everyone leave the BOC room. We will work as expeditiously as possible to have this conversation and come back out of it. And at that time, we'll have a public discourse and make a decision.
Are we okay to leave our stuff?
Absolutely.
Madam Chair, if I could, I would like to correct a statement I made earlier for the record. I misspoke when I said that a map had been chosen by the board, but a map had not been chosen. A map had been implemented by the board's understanding of the supersedious in this case. And so I just wanted to make sure the record appropriately reflected that.
Excellent.
Thank you.
And while we are ensuring that items are on the record, a couple of things. Director Fall, you made mention of email correspondence, I believe, between yourself and Ms. Grubbs, or was it Ms. Childress, in connection with the submission of Ms. Adams' qualifying materials on March the 6th?
The email communication was between myself and Ms. Grubbs. The original qualification packet was submitted by Ms. Childress, and that's who the letterhead letter that's included in that packet is from. But the email and then the corresponding emails back and forth were between me and Ms. Grubbs.
Okay, sounds good. And then also, I did speak with Mr. Boring prior to the start of this proceeding and inquired as to whether he would be calling any witnesses. He indicated that he would not call Ms. Adams. He did not indicate that he wanted to call Ms. Grubbs. And so perhaps it was an oversight on my part not to call Ms. Grubbs. But initially I was informed that Ms. Grubbs would not be here. And en route to this hearing, I spoke with Ms. Grubbs. I do note that Ms. Grubbs is here, and my colleague has indicated that she believes it appropriate for us to hear from Ms. Grubbs in light of the fact that the Cobb Republicans performed the qualifying process. Ms. Grubbs, is there anything you would like to add? Please.
Thank you very much. I appreciate you giving me the opportunity to speak. This is one of those cases where it has become a hot mess express. Excuse the slang, but it is a hot mess express. And the one thing that I would like to clarify is that in submitting, you mentioned the emails going back and forth with me and Director Fall. The reason that I submitted an email is because I have been asking since January for clarification on which maps you intended to use. The public is confused, residents are confused, candidates are confused, and following the legislatively implemented, drawn, the gubernatorial signed, and the judge upheld maps only make sense. But the reason why I submitted it the way I did is because I was not getting any direction. And clearly, after the 11th hour, when you all changed course, I mean, clearly we voted on the maps in the 2022 election. Now, all of a sudden, we're using the home rule maps without any particular reason except an attorney opinion. With all due respect to Mr. White, you're not a judicial body. There is a separation of powers issue. And so the reason why I worded it the way I did to Director Fall is because I'm saying, I don't know, I don't want to make a misstep. Someone needs to clear this up. And the reason I did not do that with Pamela Reardon's submission is because you had just chosen to use the home rule maps. So there was no motive behind what I did other than to say, you've already chosen the home rule map, so clearly you're not going to have an issue with it. I did it with Ms. Adams' map because I believe we needed further clarification. So I appreciate the opportunity to speak. If you have any questions, I'm glad to answer them.
Okay. I don't have any questions. I also, just for purposes of the complete record, note that this afternoon, Ms. Grubbs directed an email to a large number of people, including members of this board, members of the General Assembly, members of the Board of Commissioners, wherein she's made certain requests related to the parties entering into some type of agreement, and that being the parties to the Floam litigation, of which this board is not a party. But I did want to ensure that this email that you sent to us was properly entered into the record.
Thank you very much. I appreciate that.
Thank you. At this time, I will entertain a motion with respect to the challenge, a determination made with respect to the challenge.
I move that we find that Alicia Adams is not eligible to hold the office that she seeks because she doesn't meet the residency requirements, and to uphold Ms. Seeger's challenge.
Okay, is there a second?
Second.
It's been moved and properly seconded to uphold the challenge as presented by Ms. Seeger with respect to Ms. Adams' candidacy, as she does not meet the residency requirements for the position she seeks. All of those in favor? Any opposed? Ms. Fisher's opposition has been noted. The motion passes on a 4-1 vote. Notwithstanding the oral decision that we've provided here on the record, a written decision will be provided. You have Mr. Boring's contact information?
Yeah, I'll send one to Mr. Boring, and I believe we have Ms. Seekers as well.
Okay, okay. And then, as noted earlier, there is, the code provides an opportunity for appeal, and obviously your counsel will share that information with you. So I do appreciate everyone's presence here this afternoon, and I also appreciate my colleagues and you, Mr. White, as well as you, Ms. Fall, as we continue to move forward in preparing for the election come May 21st. I don't believe that there is anything further other than the next meeting of this board will take place on Monday, May the 18th. I'm sorry, March the 18th. I already want this election to be over and done. But March the 18th, right here at 3 p.m. And if there is nothing further, then this meeting is adjourned at 4:34.